start. The petitioner in the instant case is Wing Commander Rajesh Singh Nagar, a member of the Air Force who was sent to the state of Uttar Pradesh on deputation for 3 years, later extended by another year. The facts of the case arise from a 2008 aircraft accident of a plane flown by the petitioner. After the Directorate General of Civil Aviation (DGCA) investigation, he was permitted to resume the flight duties after attending corrective/additional training. However, in 2014, a charge sheet was issued against the petitioner for a 6-year-old accident and another accident where he was involved in 2012, following which he was terminated from service in 2016. The court noted that under Clause 3 and 8 of the 2012 rules, the objective of the investigation is the prevention of future accidents and not to apportion blame or liability. Furthermore, on the first issue, the court noted that the petitioner was an employee of the Indian Air Force working on deputation with the state government at the time of the accident. In this regard, it noted the services of an employee on deputation cannot be terminated by the borrowing department in case of any negligence or misconduct. He can only be repatriated to his parent department along with the report about his conduct. Furthermore, the court refused to condone the delay of 6 years as the explanation provided was found not satisfactory. It noted that delayed initiation of proceedings is bound to give room for allegations of bias, malafides, and misuse of power. Moreover, it is likely to cause prejudice to the delinquent officer in defending himself. Thereby, the court held that the delay and laches on the employer's part would vitiate the disciplinary proceedings, held it to be illegal, arbitrary, and an abuse of power. The inquiry by the AAIB, the court held that the authorities were influenced by findings of the preliminary inquiry at the very first instance. As the preliminary inquiry is merely a fact-finding report, the object is to form an opinion as to whether a formal inquiry is required or not. The findings of the regular disciplinary proceeding is ordinarily not to be relied upon, it noted. In case such a report is to be relied upon, then the delinquent employee has to be confronted with such materials, and only after hearing their version in the matter that such a report could be relied upon. Any other course followed would clearly be a violation of principle of natural justice. The state government was held to be premeditated and malafide, which is substantiated by a frequent change of the inquiry officers who could align with the authorities' wishes. It was also held that the petitioner has not been given the proper opportunity to submit the reply of the show cause notice, as he has not been supplied with the relevant documents. It was also noted that the report does not indicate that the pilot erred in making last-minute corrections or that there was any negligence in following the due procedure. Stop.